Good afternoon, everybody, and welcome to this webinar on access to justice in 2020. My name's Mark Beyer. I'm the editor of Business News, and it's a great pleasure for Business News to be jointly hosting this event with the Law Society of Western Australia. I'll quickly run through some brief housekeeping matters before we get underway. The event is scheduled to run for 1 hour. We've got quite a few issues to get through in that time, and we've got a really good panel, so we'll keep things moving along briskly. A brief reminder for people who are watching the webinar, the chat function is disabled, so you will not be able to use that. Regarding questions, we've already had several that have been submitted by people who are watching the webinar, and we'll endeavour to get through those as we go along. I'd like to introduce the 6 panellists who will be joining us today. Unfortunately, the Attorney General, John Quigley, was a late withdrawal. He had been keen to participate, but was not able to make it. Nonetheless, we've got the Honourable Peter Quinlan, Chief Justice of Western Australia. We've got Nicholas Van Hattem, President of the Law Society of Western Australia. Claire Mould, a Senior Associate and Pro Bono Coordinator at Cause Chambers Westgarth. Corina Martin, Chief Executive of the Aboriginal Family Legal Service. Sharryn Jackson, Executive Director of Community Legal Service WA, and Shayla Straps, Chief Executive of the Mental Health Law Centre. I'll now hand over to Nick to talk a bit more about Law Week and the event coming up.
Thanks very much, Mark. As co-host, it's my honour to acknowledge the traditional owners on the lands on which we're virtually meeting today, and the lands on which we practice and the Law Society is based, the lands of the Whadjuk people of the Noongar Nation, and acknowledge my respects to their elders past, present and emerging. And it's great to join you all for this Law Week virtual forum. I've said before that I think Law Week is the most wonderful time of the year, and I really do. I think it's a great week for us to celebrate the work of lawyers, reflect on the challenges in access to justice, and ultimately to talk about and engage with the community about the rule of law. And we've been off to a great start this week. Our calendar is usually jam-packed with activities, and sadly, for reasons of COVID, it hasn't been quite as busy with the live events as we would have liked, but we've still got plenty on. The Walk for Justice yesterday was an absolute ripper. I think it was the largest fundraising goal we've ever had. So while we had some concerns about how are we going to do a walk virtually, it's actually the biggest walk we've ever had. And it was great to have the Honourable Peter Quinlan launch the walk with his co-star, Bonnie the dog. So it was a great day yesterday. We're really excited about this forum and delighted to have so many people tuning in to hear from our panel and hear about some of our discussion about access to justice in 2020. There's also a photo challenge that I'd like to bring to everyone's attention. We've got a lot of practitioners might have seen a few admission photos being posted this week with the hashtag Lawyers Make a Difference. And it's a reminder to us all that there are many paths that practitioners might take, and many of us at different places along our journey in our profession. But it's been a fun activity this week, and everyone can get involved. Please do, if you're listening, post your admission photo and get others to do the same. Tag it with Lawyers Make a Difference, and it's a fun way to sort of reflect on the impact we can all make in our own professions. And I'd finally just note that we are increasingly trying to engage with our regional practitioners. And so at the end of Law Week, as has traditionally been the case, we're running a special CPD for regional and remote practitioners so they can tune in and get a large number of CPD points, but also stay connected and hear from some experts. So I'm looking forward to launching that on Friday. So that's a bit of an overview, Mark, and I think we can move to our first question.
Very much, Ken, yes. Now, look, it was 1 month ago that the state government announced the new pro bono model under which law firms providing legal services to the WA government are expected to meet targets for the amount of pro bono work that they undertake. I'd like to have a discussion about how much difference that's going to make. So let's throw that open to the panel, and perhaps Claire, you could kick off the discussions on that one, given your role.
Oh, absolutely. So I believe it will make difference. I think that the new model will act as an incentive to firms to provide more pro bono legal services, and by providing more pro bono legal services, that of course means a greater access to justice. So I just thought I'd highlight, in 2016, the Pro Bono Law Centre conducted a survey, and that survey showed that the majority of pro bono legal services provided across Australia were provided in New South Wales and Victoria. Now, of course, there's probably more lawyers in New South Wales and Victoria as compared to WA, but it's important to highlight that at that time, it was New South Wales and Victoria that had the government mandated minimum pro bono requirements. So what we've got is that link between, governments mandating pro bono requirements and the amount of pro bono activity that lawyers engage in. So I think, by WA implementing this new model, using New South Wales and Victoria as, as an example, I think it follows that certainly there will be a greater amount of pro bono activity, which means greater access and an improvement in access to justice.
Yeah, look, Claire, as a follow-up to that, could you talk a bit more, what's your sense about how much variation there is across the profession, and what other things could be done to encourage greater pro bono activities across the profession? And then I'd sort of throw to other people on the panel for their experiences in this area.
What else could be done? Well, certainly it depends on the firm's capacity, I guess. If you're a small law firm, you might be more restricted than a larger firm that has more resources to throw at pro bono activity. So look, I think first of all, let's get this model implemented and see what difference that makes. Yeah, I'll have to have a think. Let's throw to the rest of the panel, and I'll have a think and come back to you.
I think if I can jump in from a CLC perspective, this is just really great because it provides for the coordination as well. I'm a director of Law Access, so I'm probably a bit biased about what a great organisation they are and the great work that they already do in linking up individuals with pro bono resources. But this also allows for a really great partnership between Law Access and CLCs, and also will flow onto individuals. So I think anything that allows for those type of coordination activities helps the law firms who might find themselves with capacity to give from a pro bono perspective, but also reduces the load on CLCs who don't have to spend time and resources in trying to actively go out and find where those pro bono opportunities are.
Can I just reinforce what Shayla said, Mark? We're very excited to see the new model, looking forward to working with Law Access and actually trying to make sure that we maximise, if you like, people's access to pro bono support. We as a sector are incredibly reliant on our volunteers and on our pro bono partners, and we have worked closely with them over a number of years and looked at ways in which we can create even greater shared value from pro bono services. So this opportunity to have coordination provided by Law Access to assist with warm referrals, I am convinced we'll see many, many more people being able to access justice. So I'm very pleased.
I'd like to hop in there as well. We use a lot of pro bono lawyers to assist us. One of the things though is that we only do work in the regions, so the cost of, if we need a pro bono to go to do some work in the regions, it's a high cost. And one of the other things is we would like to look at whether the law firms are able to put someone in one of our offices or in an office to actually work with our lawyers on some of the matters, and more training for people in regards to particularly child protection matters. The regions tend to always miss out on having some of these services. However, I we have, as I said, we have worked with Law Access, and we have a number of pro bono lawyers that we really appreciate the service and the assistance that we've been given. But I'd like to see a program where you actually have someone from one of the, particularly the bigger law firms, and particularly in some of the civil areas, that can actually go into and do some work, actual work within our office. Thanks.
Okay, well, look, there's mostly a positive tone to those comments. You've thrown out a challenge to the big firms there, so hopefully you can have some constructive discussions.
Can I throw out a bit more of a challenge? Noting, as I do, what the importance of the government's pro bono requirements done, as others have talked about, is assist in putting structure around the provision of pro bono services to individuals or to CLCs or through organisations such as Law Access, etc. You asked, Mark, at the outset, really what more can be done? And perhaps I'd put in two ideas in relation to that. The first is to endorse what Corina said in relation to finding different ways to deliver pro bono assistance, which involve particularly large firms being able to, in a sense, second their lawyers into places where pro bono legal services are needed. I can remember back 25 years ago or 20 years ago, for example, one of the large tax firms in Melbourne sending one of their lawyers to work in the Pilbara in the Aboriginal Legal Service for a year. That was a long time ago. But that has a couple of benefits. One, I think you probably get more immediate direct benefit. And the other thing, of course, is that part of the difficulty that a lot of the big firms have now in light of their commercial relationships and their client bases is the problem of conflicts. One of the areas in which we have in the Supreme Court or an ever-present need for legal assistance is with people in distressed mortgage situations who are dealing with mortgage possession applications, and they're against banks. And banks are clients of big firms, and there are real difficulties for a firm to be able to provide pro bono legal services to a person such as that, when in fact their client may well be the bank in question. So the kinds of processes that Corina's talked about, I think, assist in dealing with those kinds of obstacles. So that's one thing. And the other thing is to say, which I'll say now again, because there may be people who haven't heard me bang on about this everywhere, but the promotion of pro bono legal services or access to justice more generally, because I think access to justice is an issue which is much wider than simply what we might traditionally regard as pro bono legal services, is something that has to start, as it were, not at the point of obtaining government work or being in a firm. It is about the first day of law school of a law student understanding that they are going into a profession with obligations which they will always have and which extend to providing access to justice to those who would otherwise be unable to afford them. So there are both these mechanistic ideas that I think these programs are very good for. There's also an important cultural element that that really we have to start at the beginning. And I know from the law students that I see that a lot of them have a great commitment to that kind of a notion of professionalism. It's a matter of harnessing it and continuously reinforcing it throughout a lawyer's practicing life. So that's probably a more difficult one to put into a KPI in terms of producing pro bono services, but I think it is immeasurable as it might be in some respects, just as important as the kind of mechanisms that we've talked about.
Mark, before we move on to another topic, can I just take 30 seconds to pull some of those strings together as well? Further to Corina's challenge, and which was reinforced by the Chief Justice, I think there's a particular need for regional support, and it has particular difficulties. Happily, increasingly, firms and individuals are supporting pro bono efforts, but there are additional challenges not only to the service providers in the regions, but in terms of getting the assistance there. And it's as basic as a food and accommodation, that if we're asking people to live away from home, there are additional costs. So there have been some success stories. The Piddington Society has had some limited success with Kalgoorlie, also partnering with, I think it's one of the universities, to provide some student accommodation. So the reason I say all this is we've got an exciting opportunity today with more than 200 lawyers and law students joining this conversation. Any one of them might have some ideas about how do we solve some of those individual problems, because it does really require a team effort. Can someone provide some help towards the accommodation cost? Can someone provide the relevant supervision? Where is the need greatest? And so if people do have ideas, we'd love to hear them, and people can contact the Law Society, also Law Access, because precisely how we're going to solve some of these problems, I think, will require that team effort.
Okay, look, thanks very much, Chief Justice and Nick and everyone else for your comments on that topic. Look, the second theme we wanted to explore was around legal processes and procedures. It seems that the COVID pandemic and the restrictions around that have actually shone a light on some long-standing issues in this area. And topical matters in particular include the use of digital signatures, electronic lodgement and remote access to courts. We're all set to ask the Attorney General about his agenda on these matters. As we said earlier, he's unfortunately not able to join us, but I'm sure these are issues that all the panellists will have insights into. Sharryn, could I throw to you perhaps to kick off discussion on this one as to what you're looking for to see some real improvements in this area?
Funnily enough, Mark, one of the things I have to say about our sector is that we are incredibly poorly resourced when it comes to IT infrastructure. And as much as we use, and as Corina's indicated, especially in the regions, as much as we rely on that sort of online presence, I have to say that there's a slight investment that's required when you've got some centres that are still working on Windows 7, for those of you who are tech heads, or have computers that are somewhere between 4 and 14 years old. It's very hard to do anything online or by video conferencing. I'm pleased to say we have an ICT strategy in place, and some of the Commonwealth money that was announced that you're going to be talking about soon was actually dedicated towards infrastructure for IT. One of the things I'll say about the courts during the COVID-19 crisis is that we have been incredibly appreciative in the main of their attempts to try and assist us and those who represent clients or have matters in the courts to try and deal with them as expeditiously as possible. However, I'm concerned that some of those kind of reforms or consistent practices might well disappear if people think the COVID-19 crisis is over. And I'm sure for those of you who are much more activity in the court are aware of the kind of backlog that's there in every single one of our courts. And I think the more we can do to look at, consistent policies and consistent ways of dealing with applications, better case management, they're all necessary to complement electronic and online ways of doing things.
Yeah. Who'd like to go next on this one, and any specifics about changes you're keen to see?
I might jump in if I can, Mark. I think what our lawyers have seen, and our lawyers appear in the Mental Health Tribunal, across the Magistrates Courts, and also in SAT. And so I can echo Sharryn's comments about the tribunals and the courts. We've been very supportive of the measures that they've put in place. I think what's important as we sort of perhaps start hopefully seeing the light out of this crisis is to think about what it is that we've learned out of this and what it is that we can carry into the future. And as with everything, there'll be some positives and there'll be some negatives. So I think, for example, we've seen some great positives around saving time, much less time that we're spending driving to and from courts, particularly some of the Corina, they're not regional, Mandurah, Rockingham, some of those courts that take us an hour or so to get to. You know, we've seen some time savings around that. So when it's simple adjournments, being able to deal with those by the phone saves huge amounts of time, not just to us, but also for the court. So those are really great positives. But what we've also learned, particularly for our vulnerable client group, is that sometimes they need someone standing there with them in person, that is really important to them. And so I think it would be really great if we see across the justice system us being able to carry some of those really positive things that we've found out of this into the future, so that it does free up some resources for both the lawyers but also for the courts and the justice system, so that we can really try and direct those resources to the really vulnerable population, because they're the ones that perhaps need more than the average Joe who might be down at the magistrate's court for a more simpler matter.
Shayla, I wonder if you can also tell us a bit about what Mental Health Law Centre has done in terms of its own IT. I think there's been a significant investment and not everyone's in a position to do that, but you've had some success there.
Yeah, so we've, over the past couple of years, we have invested heavily in our IT systems, and so that's great, I suppose, to once the COVID crisis hit, we were really in a position where we were able to basically work from home the next day. We had invested in that infrastructure, and so that's really put us in a position where we were able to adapt quite quickly. As Sharryn says, not all CLCs have been able to do that. And I guess what is often frustrating sitting in a CEO's chair in a CLC is that the funding mechanisms don't always allow you to do that. So there's not the funding mechanism that will allow you to invest in that, or you might be directed to use a particular kind of database which actually doesn't allow people to work remotely. So there has to be an acceptance, I think, across funders that if they're not allowing the organisations that they're funding to give them feedback and for them to be innovative and to be open to change, then we're all going to be stuck back in, well, basically 2000, where we did have databases where we had to be sitting in our office and working. And I think, Corina, to your point, the great thing that we've learnt over the past couple of months is that we can have lawyers sitting in regional offices, because they don't actually have to be sitting on the chair in the regional office. What our staff are telling us is that they've never felt more connected throughout this, which I find ironic, but it's because we're having more of these kinds of meetings. So I think, you know, the COVID crisis is just opening up massive amounts of opportunity for the legal profession to be innovative and to learn.
Yeah, I'll jump in here too. We've in the regions, we've virtually been doing many courts remotely and by video link or by telephone. We've invested quite a bit also in regards to technology. We did it prior to COVID-19, where we're on a, I think it's called a 3CX program, where lawyers can actually take their phones. It's connected to the internal internal extension. So instead of ringing a mobile number or the office number, you just ring the extension. As long as there's Wi-Fi around, people can get access to it. However, with regards to the remoteness and courts being done online or by video link, it depends on the courts and how many people can actually link in at the same time. So, you know, someone might be able to link in by phone and another person by video link, and that's it. So, you know, and quite often our clients do need someone to be there with them to represent, but they also need to know and follow what the processes are, and I think that sometimes can be lost in terms of appearing by video, because everything's done so quickly. You know, it's a rotational very quickly, and people don't fully understand, and so you have to spend a lot of time explaining, because we've got to be reminded that a lot of the matters that we deal with are the client's matters and not the lawyer's matters, and so the client has to be aware of the processes and what's going on within their own matter. Yep. But other than that, we've been doing it for many years.
Okay, thanks.
There is an issue though. There is one issue in regards to that is affidavits that go through, and this has come up with the new online violent restraining orders. Is that lawyers are not supposed to sign affidavits that they're writing up. So that is a bit of an issue. How do they get a witness in regards to signing online affidavits? That's something that maybe need to be looked at down the track.
Chief Justice, could I invite you to make any observations around this and any insights you've obtained during this COVID period?
Sure. Obviously, each court and tribunal is going to be a little different and be further or less further along the way in relation to certain technological matters. In the superior courts in the state, for example, we've had electronic filing coming in for various matters over the last few years, and that process is continuing. And we've noticed in particular in relation to criminal matters that there have been adjustments in relation to the provision of subpoenaed documents and the like electronically that seem to have worked quite well. Where I think the interesting balance is going to come as we come out of this period of isolation and remote work is finding the right balance between the perceived benefits of, for example, telephone hearings, and the benefits that come from in-person appearances. And a lot of the feedback that I've had in relation to, for example, directions hearings, case management lists, matters of that kind, is that appearing by telephone has been quite effective and has been very cost effective and time effective for practitioners, where an appearance that could have taken a couple of hours can be done in a matter of minutes because of the lack of travel time, etc. And certainly it's been suggested to me both within the court and from outside that those advances are not something that we should lose as we come out of this process. I will quickly add a little advertisement here though. Because you can attend by telephone doesn't necessarily mean that you shouldn't try and resolve things before you get to court. It's been a rather interesting matter that, for example, if you've got a case management conference list with 8 matters in it, traditionally, most of them fall away in the days leading up, and you've got 1 or 2 when you get on the day because the others have been resolved by consent. It would seem, and this is only anecdotal, that where you can dial in from your bedroom on the telephone, all 8 will go ahead because the incentive doesn't seem to be there. But that's a little aside. What I wanted to really say was that as useful as those practices have been, I think it is incredibly important that we do not lose, particularly in relation to trial hearings, substantive hearings, the fact that the courts are public, they are personal, they are, in a sense, performative in displaying the provision of justice, and that there are some aspects of the justice system that are incredibly important for the broader respect of the rule of law that would be lost if we went to a predominance of substantive hearings by processes such as this. And I'll just give an example. At the moment, I'm looking at a screen. I can see 6 other people. I can see that some are well, you're all listening, of course, but I'm told that there are a couple of hundred people maybe tuned in. I can't see any of them. I don't know. I can't get any sense of who they are and what's going on, or any of the kind of matters that when you're in a courtroom, in a public court with members of the public, are important matters to reinforce the the particular governmental nature of public administration of justice. So it's really a matter of saying, I think it's going to be a matter of finding that balance where for those matters which really can be and ought to be dealt with as speedily and as efficiently as possible, that we harness some of these steps that we put in place and that we keep at the forefront of our minds the importance of the public aspect of the courts and of the administration of justice as we move into more business as usual.
Okay, thanks very much for that one. I think it's time to move on to our third topic. And once again, this is a follow-on to, or tied into the COVID period. And the sense that the restrictions that we've all been living through and the social isolation and so on, it's highlighted concerns around things like mental health, both in the community and I think in your profession, issues around domestic violence and tenancy. And the Australian government acknowledged this to a degree earlier this month when it announced an extra $63 million in funding for frontline legal services, specifically to deal with issues like domestic violence, tenancy disputes, insurance and debt-related problems. Now, this might be a rhetorical question for some of you, but was this enough money? How much difference will it really make? I'm keen to hear your thoughts on this one. Who'd like to kick off this discussion?
I'm happy to start from the community legal sector. I can say that the funding is welcome, but I have to say it's certainly not enough. For most community legal sector organisations, and I suspect for most of the legal assistance sector, we were already starting from a point of disadvantage where we were a long way short of meeting the existing legal need in our community, especially in the civil area. And so whilst this money is welcome and whilst we'll hopefully see it allocated and distributed where it can have the most impact, it's going to still be a long way short. Our centres are already reporting significant increases in demand for advice and assistance in the areas of tenancy, in employment law, in social welfare law, and in FDV. And just to give you one example, our Welfare Rights and Advocacy Service was flat out trying to assist their share of the less than 1 million people who are on unemployment benefits. We now have nearly 7 million people who are in receipt of some sort of employment-related benefit. And, if robo-debt was a small example of what could happen when people are faced with debts or questions of entitlements and all the rest, we've got a massive amount of work coming. We're trying to work with the Attorney and with the Department of Justice to also identify social policy levers that we might be able to tweak to try and kind of, if I can use the phrase, flatten the curve or the tsunami of demand that's coming towards us. And for example, there's still siloed thinking in the family violence space that, support for family violence victims is sort of in one area, legal responses to family violence is in another area. So it's not part of the basic protocols for dealing with a reported domestic violence situation for that victim, or indeed the respondent or perpetrator of violence, to be told that they could and can access legal advice or assistance. And I'm kind of coming from the place where most people, if they have good information about their rights and responsibilities, will act in hopefully more sensible and in more sensible fashion, and might just help reduce it. If we could get our experience is people don't come to us with one simple legal problem. In fact, there's many reports around that talk about the complexities of the issues that people come to us with. Over 60% of FDV sufferers, for example, will have 2 or more other related legal problems, usually tenancy, often credit and debt, sometimes employment. If only we could get community organisations, both public and private, to apply, for example, a simple legal health check to identify those legal problems as early as possible so that they can be referred for advice and assistance before they spiral out of control, before they find themselves being pursued by debt collectors and the like, that would be absolutely fantastic. I think we're in for a really, really torrid time, and I'm very glad that the pro bono model support, for example, Claire and Shayla and Corina is come on board. Maybe that will help us a bit, but I think there's more that we need to do to try and find avenues to allow those people to access as early as possible legal advice and information.
Okay. Shayla or Corina, would you like to add to those comments?
Yeah, I mean, I think like Sharryn, we certainly welcome that funding. We know there's going to be an avalanche of mental health issues from across the community, and we're already beginning to see those. So we certainly need to be prepared. As with most things that are funded through the federal government, WA see a very small percentage of that money. Whilst it sounds quite impressive, 63 million, there won't be anywhere near that coming towards WA. I think to Sharron's point, our clients and all CLC clients are complex. They have a raft of issues that don't neatly fit into one basket. The issue with the current funding models are that the government tries to fund out of each government portfolio particular services, so legal services and social services and accommodation services. And when you've got a client who has issues across all of those items, it's really difficult for the client. They have to go over there to sort out their accommodation, they have to go over there to sort out their legal, they have to go over there to sort out whatever else they're trying to sort out, and that is very tiring. And for someone who is unwell and who has been facing that for a long period of time, it's often not just doable, and that's why we see people spiralling down into crisis. So we'd really like the government to look at rethinking how those sorts of services are funded, and we've recently merged with Rua Community Services, so we've been able to put a model in place where we have social workers working alongside of our lawyers. And we'd love to do that in other areas of law, but when you go and have those conversations with all of the ministers, they say, oh no, that, you know, we don't fund lawyers, or oh no, we don't fund social workers, because it doesn't neatly fit into any one of those portfolios. So there needs to be some rethinking, and I think coming out of COVID and where everyone has been prepared to try so many different things, it would be really great to see that flood across perhaps some innovative thinking around funding models.
Nick, could I throw to you?
Sorry. Oh, sorry, I was going to add in, but if you want to go through it.
Yeah, go ahead, Corina.
Okay. With our clients, all our clients are Aboriginal clients and all regional, and across, we operate in 6 different regions within WA. We also have a model in 2 of our regions of having social workers work with our lawyers. And with Aboriginal people, because of the trauma that they've suffered that still hasn't been resolved, there's more and more crisis situations. When a client comes in, it's like peeling an onion. There's layers and layers and layers before you actually get to the legal issue. It may not even get to a legal issue. So you need to have those support. Legal centres are not just for lawyers. You really need to have those support systems in place for the clients that come in, and be able to provide the services that they require. There's so much money that goes into services. As Shayla said, you have to go to one service for this matter, you have to go for another service for another matter. There's and a lot of those services are very limited in the regions. Counselling is such an issue in the regions in regards to that, and proper counselling as well. There's you know, you've got to take into the Aboriginal aspects. I mean, we're not all the same. You know, there's over 40 languages around. So, you know, and we get logged as being one Aboriginal group, but we're all very, very different. I'm from up in the Kimberley, so I'm from 3 different language groups up in the Kimberley, you know, and those needs need to be taken into account in regards to the culture of people as well. So, but it is, we don't get any state funding. For some reason, the state don't recognise us as being part of the state, really. But you know, and like Shayla said, you go to one, you know, say the AG's department to seek funding, and the areas of law that we deal with, they say, no, you've got to go to the Minister of DV for funding. So we're kind of like a ping pong ball, really. We get pushed between the one department and another government department, and at the end we don't receive any funding through the state. It's all Commonwealth funding. That's very frustrating for our service, and particularly in regards to working with our clients and our client base, and just seeing the waste of funding that goes to services that really don't do anything. So, you know, and not giving Aboriginal organisations an opportunity to work with our own people in trying to develop a better model. Thanks.
Okay. Look, I was wanting to raise a variation on that theme. You've commented about issues across the community at large, including mental health issues. But Nick, I know the Law Society, like most professional associations, is very focused as well on mental health of your members and the pressure that lawyers come under. Is that something you'd like to comment on here? And to what extent, you know, that is a concern for the Law Society?
Absolutely, thanks, Mark. Can I comment on two other things and then come to mental health? In terms of the question about the 63 million, was it enough and will it make a difference? The position is that the community assistance legal sector is chronically underfunded. So under the Howard government, there was a structural change to the funding model and it's never reached appropriate levels since. And that's not just the lobby group saying that, it's the Productivity Commission saying that. And people are nodding enthusiastically because it is the case. So these announcements are welcome. I think Sharryn used that language and I respectfully endorse that. But there's a lot of ways to go. So we'll maintain the rage, I suppose, in relation to the funding issue. And the other thing that the profession can do is act as efficiently as possible. And there's been some reference to the witnessing of documents. There was a question from one of the delegates today about measures to bring in new measures to witness documents. It's an example of how we need to respond. So there are more inquiries, sadly, around wills during this pandemic, because a lot of people are thinking about, well, are my affairs in order? And there's an example where it's really hard for the legal profession to respond to that particular challenge, because with social distancing measures in place, it's that much harder to arrange for witnesses of documents. So it's regrettable that the attorney wasn't able to join us. That's a particular matter that the Society is advocating on and following up with his office to say, what is WA's response going to be? And we have been told as late as today that they are working on it. Government is working on it, but it's an example of how government needs to assist the sector so that we can efficiently serve the community. But to come to your question, and sorry for that diversion, mental health is a huge issue for the profession. I think it's the #1 issue for the profession and a huge focus for the Law Society. Law care is an example of this, where during difficult times and shocks to processes, we anticipate a lot of people are going to need some help. And so we do encourage people to contact our confidential service for a bit of counselling as a first measure. But it's been interesting for me to reflect on my colleagues' experience during the pandemic. I can safely say and openly say that it's been a depressing episode for me and practitioners like me who really thrive on the contact that we receive from the community. And so to be isolated from that makes the job really difficult. Happily, there have been some attempts to do a degree of staying connected, because I think it is so important for practitioners to stay connected. And so Zoom is pretty good. And I have been assisted by seeing people's faces and being able to discuss matters. But I'm very much looking forward to more face-to-face socialising. And I know a lot of my colleagues are as well.
Okay. And on those broad themes, Claire, I don't know if you wanted to add anything, or Chief Justice, if you had any thoughts.
Yeah, I agree. I know that a number of my colleagues and myself were very keen to get back to the office. As Nick mentioned, in this profession, it's it's really important to have that sort of team environment, especially for junior lawyers. I know a lot of junior lawyers really struggling. You know, as lawyers, it's a pretty stressful job, and especially you know, as a junior lawyer, whereas in a team environment, when you're with people, you can just, you know, go around to your partner's office, ask a question. When you're at home alone, trying to, you know, figure out how to approach something, it can be quite, you know, an anxious and overwhelming experience. So yeah, certainly looking forward to getting back into the office.
And Chief Justice, is there anything you wanted to add, or is that one covered enough?
Yes, it is. It is to a great extent. The interesting thing for me personally is that while I haven't been able to see people, friends and so on, who work in the city during the week, and restaurants and so on aren't open, the one experience that I personally have not had in the course of this process is the working from home isolation. That is, I've been in my office every day during the COVID isolation period, as have most of my team. So I have still personally had the opportunity to see a lot of people in the role that I am from time to time. But it is, and I imagine this is the case for a number of the other panelists who are CEOs. It can be quite stressful, though, as a manager of human beings, though, not having the contact with all of them and not being sure how they're all getting on. It's very difficult when you have had, as it were, your workforce dispersed for a period of time, knowing how they're all getting on. So in a sense, from my point of view, those isolation stresses has been something which has been a referred issue rather than one that I've directly had to deal with. But I certainly will be pleased when the restaurants in the city open up for lunches again, and people flock back into the CBD.
Okay, thanks very much.
Can I say something? I actually love working from home because I don't get any of the disruptions. Because we've got regional offices anyway, and there's 4 or 5 staff in each office, we do use the virtual communique to catch up on staff meetings and whatever. But we have every week, we have staff meetings, and all the staff have their meetings, and none of our staff wanted to actually work from home not many of our staff wanted to work from home in the region. So because of the different regions and the areas and the full lockdown that's happened in those areas with the borders, that many of the staff did do a rotational basis, and it's always the lawyers that tend to go into the office and work, and the admin staff, and they really enjoyed it, doing it that way. But everyone's back on board now, which is
Corina,
good. Yep.
Thanks for that. I think it's such an important point that we're all different, and I suspect that there are probably lots of lawyers like Corina who get really annoyed by lawyers like me who are in the workplace saying, "Hey, let's have a chat, let's talk about things." And so the balance is important. I think it's absolutely right. There've been so many positive stories coming out of the work from home thing. We've heard about some of the efficiencies, and look, I think that will be a trend. I think officers are already talking now about how more staff will want to work more often, more flexibly. And I do think on balance, it's a good thing for sure.
Okay, thanks for that. Look, we've got just over 10 minutes to go, and we're rolling along on schedule, so that's a good thing. The next topic we wanted to talk about was around justice reinvestment, and this raises all sorts of issues around rates of incarceration, which clearly disproportionately affect Aboriginal people. Now, Nick, could I throw to you, because the Law Society's law program, I'm not sure how we say that with explaining it properly to people, but perhaps you could talk a little bit about that, and then we could throw that issue to the panel.
Thanks, Mark. Justice reinvestment is a concept that the Law Society is really supportive of. The Law Project is an example of that. And just to explain the difficulty in pronunciation, it's law in the sense of L-A-W and L-O-R-E, so referring to traditional and cultural L-O-R-E as well as law. And it's an example of a project of finding essentially at-risk individuals, in this case, younger Aboriginal people in regional places, and engaging those individuals in the community with the concepts that we focus on in Law Week: education around law, the rule of law, access to justice, and these things, with a view to reducing any stigma or fear with those sorts with that process and with the justice system. So it's been a successful program, and it's a reminder that we need to be turning our attention not just to what's happening where we can see things in the city, but focusing on regional areas as well. But I think more broadly, and I think everyone will be able to comment on this, social justice reinvestment is a really important concept, and it has already emerged as a theme in state politics and will continue to be one. The Society anticipates over the coming months we're going to be hearing what is the justice agenda to come. And the Law Society is very supportive of measures that will serve to both reduce crime and reduce costs to the taxpayer. So our strong position is, for example, that putting more people in jail for longer does neither of those things, whereas using funding more strategically and innovatively is generally going to lead to better outcomes. And there's a very nice example I recently heard in the Start Court. So this is a form of court that doesn't take traditional approaches to punishment and punitive measures, but says some individuals in our community need to be engaged in different ways. There was a particular individual who had been essentially living a life of crime and was in and out of prison and needed some additional social supports. And one of the things that this individual needed was some dental work. So had issues with poor dental health hygiene, for example. And so there was an expense given to pay for the remedial dental work. And as a result of that, this individual had the increase in self-esteem and had the social supports around him so as to be able to find employment. And now we have this person who is in and out of jail, now a tax-paying member of the community. And that was cheaper than locking this person up for a year, let alone 10 years. So this does require nuance. It does require more sophisticated conversation than just let's lock them up for longer. But what we're increasingly finding and consistently finding is these more nuanced approaches to individual justice do create better outcomes.
Okay. Any other brief comments from other panellists on that one? I'm sure there will be.
The issue of justice reinvestment is going to be one that's here to stay, and as I think Nicholas was alluding to, of course, we're about to go into a state election in relation to which justice issues are always a relevant matter. I was at a conference organised by CEDA, the Committee for Economic Development of Australia, that I think Business News were reporting last year, that had a number of people speaking about justice reinvestment as a concept. And I think one of the really important things that came out of that conference that we had was that the case for different ways of spending the justice dollar, and I'm not an expert about these things, and I am not about to tell the executive government what it is to do in relation to these issues, as it would not be appropriate for me to do so. But the issue about the spending of the justice dollar is as much an economic issue to be worked through as it is a social issue. And I think that the issue of justice reinvestment is really one in which there needs to be a proper framing of the issue as one which recognises how interrelated all these things are. And I think to some extent the whole COVID process has shown that, because we've seen that health issues impact on employment, impact on economics, which impact on family violence, which impact on crime, which impact on economics, and so on and so forth. So the interrelated nature of all of those issues is one which increasingly, I think, policymakers are recognising and are going to need to look at in terms of addressing these issues. And we've already heard a number of the other speakers talk about the fact that services come from different places, and they're not necessarily as integrated as one might have hoped. So I think that's all part of the story as well.
I'd like to agree with everything that's been said on this topic. It's absolutely clear to us that if you put people and the well-being of people and their families at the heart of your approach to most things, you will achieve better outcomes for the community as a whole. And I would hate to think that as a result of, you know, all we've learned through COVID-19, we're going to revert back to a normal that has 700 people sleeping rough in the metropolitan area, that has, you know, people being expected to live on $40 a day on unemployment benefits, when we know that these issues are interconnected. The only other thing I'd say I've learned very well over my years is that there is no doubt that outcomes for Aboriginal and Torres Strait Islander people are always better when they are utilising and able to access services that are Aboriginal community controlled. And I think that's one of the other things policymakers need to do, is to start listening to what Aboriginal people have to say in their local communities about how these issues need to be addressed.
Okay. And Corina, were you keen to comment on that one, or is it all?
I agree with Sharryn. We really need to focus in regards to Aboriginal people, working with Aboriginal people, assisting and understanding, and be very mindful that we're all very different. We don't have the same culture. We all have very different cultures in each of the different regions, or countries as we call them.
Okay. Look, I'll finish up with one question that came in from one of the audience members. We've only got a couple of minutes to go, so Chief Justice, I might ask you to comment on this. And in fact, it's a flip side of the discussion we've just had in one sense, and this is around sentencing and the suggestion that in fact judges are a bit soft on their sentencing, and in particular the concern that when offenders are on drugs at the time of the offence, that is used as an excuse for a lighter sentence than might otherwise be the case. Chief Justice, any observations on that sort of comment?
Without commenting on any particular sentencing matters, I think public perception of severity of sentences is always going to be a matter of controversy, and the audience may be aware of studies in relation to the differences between public perception of what severity is and the reality of what it is. The reality in Western Australia, at least, is that certainly judges in Western Australia are not less severe, if that's the right form of words, than in any other place in Australia. And certainly in relation to the use of drugs in sentencing, there are very few times that I've ever seen it suggested that the fact that a person was on drugs at the time of the commission of the offence was itself a mitigatory factor. usually it's explicitly identified as a matter which does not excuse the conduct, which is not to say that the health issues surrounding the scourge of drug addiction in Western Australia and throughout Australia is as important an issue as the criminal aspects of it. And I think that the courts have their role to play in terms of enforcing the criminal law, but the broader system has a role to play in identifying that drug addiction is a substantial cause of a lot of offending behaviour. And anybody would only need to spend one day sitting in a sentencing list in either the District Court or the Supreme Court to see that that drug addiction and the use of drugs is only one step removed at most from almost every matter that comes before us.
Okay, look, thanks very much for your comments on that one. And look, unfortunately, the hour is up. Look, that's been a very informative and interesting discussion. So on behalf of Business News and the Law Society of Western Australia, thanks to all of you. As a result of a partnership that we have with the Law Society, we'll be producing some articles that will appear on the Business News, canvassing some of the issues that have been discussed today. So keep an eye out for that. I'd like to thank each of the panellists, Sharryn Jackson, Claire Mould, Corina Martin, Shayla Straps, Chief Justice, and Nick, I'll throw to you finally if you'd like to say a couple of words on behalf of the Law Society.
Thanks very much, Mark. It's been an excellent discussion. I hope we can do it again soon. Share your thanks to all our panellists, and thank you very much to the audience members. This has certainly exceeded my expectations, so we're really grateful for everyone to give an hour of their time to engage with these issues. Thanks very much.
Okay, and on that point, we can all sign off. Thank you very much for your time. Cheers.
Thank you.